Welcome everyone to Holistic Toolbelt Chats. My name is Cara Ockenden and I am the key to your thriving divorce or separation. I'm a relationship breakdown and divorce coach with about a decade experience in family law, and I am really super passionate about supporting individuals to navigate the process of separation and divorce in a way that really allows them to create a more thriving state throughout the process, as opposed to one where they're merely surviving or even in that drowning state. I'm also really passionate about bringing a holistic, conscious and collaborative lens to the space of separation and divorce, where we can really support individuals to do things differently and create new constructs for their family that really see their new family dynamic thrive and honour the well-being of all involved. I'm also really passionate about supporting people to avoid unnecessary conflict and unnecessary expense and financial losses they navigate through the process, by supporting them to be really conscious as they navigate the process. Of course, there are some individuals who are unfortunately in really high conflict dynamics, and for those individuals, I also love to support them to create a more thriving state in themselves as they navigate the process, and gives them tools and resources to make sure they're making really conscious decisions and not reacting from a disempowered space. I work one-to-one in groups and also with couples, so in a really holistic way. With that said, I created this series to really honour the holistic process and bring in other experts and professionals who are able to support my client to navigate the process, or my clients and audience to navigate the process in a way that really sees them thrive. So with that said, today I'm introducing a good friend of mine, a former colleague and lawyer, Brent Clements. Brent Clements is a director of Clements Fitzgerald Lawyers based in Brisbane, and Brent is skilled and expertise lies in family law, but also in litigation and estate law. Brent and I go way back to the days when he was just a law student. So I actually was part of his training back in the day in training him up to be a family lawyer. So I can really say that I can personally attest to his skill, expertise and morals and ethics. Brent also spent a decent stint in the Legal Services Commission. And for those of you who don't know what that is actually a governing body that keeps lawyers in line and gives them consequences if they commit offences. Simple as that, in their role or breach their ethics or the code that applies to lawyers. So Brent is really standing in high regard when it comes to the ethics in law. He is wonderfully personable, and I have no trouble in recommending anyone to have a chat with him moving forward. But with all that said, I'm going to now hand it over to Brent. So welcome, Brent. Thank you so much for joining me on this episode of Holistic Toolbelt Chat. How are you today? How are you traveling?
Good. Thank you for having me. Yes, I don't know. Today's been pretty good. Pretty busy so far. So
yes.
Looking forward to speaking with you.
Yeah, thank you. I really appreciate it. So to begin with, I just want to know a little bit about you and who you are, what brought you to law, to come into this lovely profession that is law.
Yes, and in family law, no less. Yes. Well, I suppose, first and foremost about myself, I'm a lawyer, obviously, practicing predominantly in family law. As to, who brought me here, lots of people, I suppose, over a long period of time, but one of which was you.
Yes.
Because, as for those who don't know, of course, we work together. You taught me a lot about family law when I was a junior lawyer. I suppose big influence there for family law. I certainly thought I wanted to do a different area of law before sort of experiencing it.
Yes. And I was speaking into before when introducing you as well about your time at the Legal Service Commission. Would you like to speak a little bit into that and how you sort of diverged for a little while and come back through?
So I worked for the Legal Services Commission, which is the office that investigates lawyers. So if you've got a complaint about a lawyer, you hit them up. And it was good work. I did a lot of litigation there, and it's sort of the other part of my practice is doing more regulatory stuff. But predominantly I do family, and predominantly why I wanted to get back into the practice of family law and law generally, as opposed to working for the government, was that I missed the the human connection, helping people with their particular matters, because I think family law touches on everyone and just normal people as well. It's just so common, and I think it's good to be able to provide a service where you're sort of helping people navigate a really difficult part of their lives. I miss talking to people, I guess. That's the takeaway.
So there's a couple of things there that I'll just touch on. I mean, I think you're right. Family law does touch on every single person. There's no way around it. Everyone knows someone who's gone through either a marriage breakdown or a separation. De facto numbers, ever increasing in terms of relationship. People are not necessarily married. I think the divorce stats are still about 50%, but I don't know that covers all relationship breakdowns, because a lot of de facto couples who go for breakdowns, and sometimes people don't necessarily go through the full legal process either when they go through separation, because there's not necessarily a need for that for some couples who don't have assets. It does certainly impact everyone, and it's not going away anytime soon, unfortunately. And when times get tough, we see increased numbers in separation. So it's more the norm than the abnorm in current society. So you do play a really critical role, and it's not a job for the faint-hearted to be in family law, that's for sure. Especially when people come into lawyers in law, we know that that's typically when there's more conflict situations and more challenging dynamics. But coming back to what you said there about litigation, I'm conscious that some people won't understand what that actually entails. So if you've just briefly touched on where you are involved in litigation as well.
So litigation is when you're actually in court. So a big part of family law matters happens outside of the court. And even once you've already commenced court proceedings, there's a lot of avenues for out-of-court sort of settlements in family law. But when we talk about litigation, that just means, documents being filed with the court, and we are in court. What you see on Suits, what you see on TV, probably less exciting, definitely less exciting. But that's what litigation is. So it's sort of the pointy end, I suppose.
Yes. And in fact, as we were just speaking before this, a lot of that litigation is now actually occurring virtually, and with judges and registers in different states across the country, with the exception of Western Australia that has its own unique different system, but otherwise it's all the same across the board. And even the legislation in Western Australia is basically similar. It's just the processes they go through over there, and the practices are a little bit different. And the court is a different court. Yes. So can you tell me a little bit about your particular ethos or mission in terms of your business and how you like to bring that through when you're supporting your clients?
Sure. Yeah. So, our motto is assertive advocacy, compassionate counsel.
I'd like that. Assertive advocacy, compassionate counsel. Yeah. So I can see that. So I can see that in you, Brent, and in your intro as well, which I'm conscious you didn't actually hear. I did touch on you being very personable, and I agree, quite compassionate, and I'm sure that comes through in the work that you in service you provide your clients. So I have no doubt about that.
Well, I think the motto does, sum it up, I suppose, because there's a lot of, compassionate counsel required, especially when people are first talking with lawyers, and later on when we get to that pointy end litigation that we talked about. And I think as well, part of our role, and I mean ours in lawyers generally, role is to, stand up for people who might find it difficult to do that themselves. I mean, that's why they're coming to you, is to have someone in their corner and to, make their position clear. And it doesn't mean you have to be, adding fuel to the fire and stoking a dispute between the couple that, hopefully we can get a solution for without having to go to court. But it is about, standing up on their behalf for them and, making their position clear, but still sort of leaving open, settlement if we possibly can.
Yeah, absolutely. And, that's something I'm really passionate about as well, is bringing in the compassionate lens to the process and supporting people to be compassionate and being conscious that, there's two individuals in the process typically who are going through one of the most traumatic events in their lives. I mean, divorce is known to be a top trauma. So just having some compassionate for the humanness of the process as well, because it is a challenging process for both parties. And if you're bringing in, a more collaborative approach, well, then it does take into consideration that humanness. But at the end of the day, like you say, there are times when there is a need for assertive litigation, not necessarily aggressive, because aggressive can sometimes just add fuel to fire, like you say, but assertive and making sure that, the clients are being advocated for and not being, pushed over, so to speak, in the process as well, or where there's some challenging dynamics as well. There may be need for more assertive litigation if there's domestic violence or risk concerns with children that need to be addressed. And there's definitely a place for that where sometimes you do have to go to court, and that's just a reality. But ideally, if you can resolve it outside of court, which is the number one approach, if you can.
That is it. That's the number one piece of advice.
Stay out of court if at all costs, if you can. But at the end of the day, there are some situations where the court's there for a reason. And that's for individuals who are unable to resolve it for themselves for whatever reason that may be. So can you tell me a little bit then as well? I suppose we're speaking a little bit into adding fuel to fire. And I'm very passionate about supporting people to get the support they need so they don't add fuel to fire. What's some common mistakes that you see that people might make earlier on in the separation piece, or when they come to you and they've already made some poor choices? What kind of things would you see that, mistakes that people make there?
Yeah, I mean, I think we've touched on it. It's just lashing out, adding fuel to the fire. I was reading some articles on your website talking about, taking a breather, taking, 24, 48 hours to respond. Stuff like that can be really helpful. I mean, it's really easy for me to say, as your lawyer, just don't respond, just keep being, nice, keep doing everything you can. But that is the advice. It's a long game, it's a hard game, but it will pay dividends eventually. You've just got to, keep yourself squeaky clean and try and be the, I don't want to say the better person, because then again, it's, I think a lot of what you're talking about is about understanding one another. It doesn't have to be that there's a bad guy or a bad girl in the dynamic, but just sort of trying not to lash out, because except for a few, particular circumstances, like when there's domestic violence involved, you do have to go to a mediation before going to court. Like, you'll have to take certain steps, like trying to settle, doing disclosure, going to mediation. If you don't go, you'll either be knocked back, told to go to mediation as soon as you file. So these things have to happen before you can even get to litigation. So if you're just, lashing out, which is understandable. Like you said, divorce is one of the biggest, trauma, especially, and it touches upon so many people. But if you do go nuclear, you are going to make it a lot harder to settle. And so you're going to be more likely to end up in some sort of protracted litigation, which it's hard to unwind from. It can be done. We see settlements happen all the time, even when people are guns blazing from the start. But obviously, if you can come in from a cool, calm, collected point of view, that would be best. And it's going to serve your own interests as well. Like, you can think of it in terms of you're helping your future self out.
Yes. I think it is challenging. And look, and I've been through the process myself, so I know how challenging it is to not react sometimes. But that is some really good advice. And in terms of reacting as well, some of the things that I saw that people would do that weren't particularly helpful was things like taking all the money out of the account without telling the other person, things like that. That sets you up for high conflict straight away. And it's not necessarily the most ideal way to go about it. And you certainly should be getting some legal advice before taking certain actions or big actions like, taking funds or even withholding children. Getting some legal advice before that is always a positive first step for taking those actions, which are most definitely going to put you in a situation of conflict. And likely in the court, like you say, people are, taking money or and children are being involved in, sometimes access does need to be withheld, but you want to be making sure that you do it the right way with legal support. That said, like you said, there are situations where there's domestic violence and things need to happen quite quickly, and that's when you want to pick up the phone and call someone like Brent straight away. And that said, even when there has been situations, in my experience, in some of the cases that you would have been involved with me, where children were withheld or where there was domestic violence orders, those cases still were resolved at the end of the day. So even if those issues are there, there's still a lot of potential to see them resolve, even if they're in the court system. I mean, most matters that don't go to trial, we know that, right? I mean, I don't know what percentage it is, but it's very few that actually end up in a final hearing.
Very few. I think I read 5% or less. I can't remember anymore, but it's a low number.
So that's right. So there's still hope, regardless of whatever situation you're in, that someone like Brent, and be able to help you to resolve that.
Yeah, and I think one of the ones you touched on is actually a big one, the withholding the child. I think a lot of people are a bit mistaken as to when they can or cannot do that. And myself and many other lawyers, you don't have to come to me, but feel free to offer free 30-minute consults. You can often book online. Speak on the phone to a lawyer who is able to give you some bit of personal advice, especially when you're talking about withholding the child. It's very fact dependent. It's not really something I would recommend just reading an article online and basing a really serious decision on. I would recommend talking to a professional. I mean, as far as some other more minor practical things to think about if you're thinking about separating, it's changing passwords is a big one. Joint accounts, again, I'd talk to a lawyer, but you can put locks on those accounts so people don't transfer money out unilaterally. That's a big one we tell people to do. Records as well, especially if you're thinking of leaving the house, take copies, because everyone is required to provide disclosure to the other party. But again, something that's easy for me to say, sometimes in practice it's a bit more difficult to get said documents after the fact. So
correct, but it's much easier to get said documents when you've got access to the bank accounts. Right. Often couples will have access to each other's accounts. It's much easier to get those records whilst you've got access, and then relying for someone to provide the information. And a couple of things I want to touch on there as well is I think another big issue that people sometimes don't get legal advice is about relocating, which is also a big factor that can lead to conflict. So that's another one that people ought to get some advice about before acting on, in my experience. But also when we're talking about, disclosing documents, I think something that I'm really present to is, it can take up to 12 months to get documents from people sometimes. And in my experience, it's not always something that's necessarily about control. It's just people don't prioritize it. People will just be, it's too hard basket. It's I've got to go to the bank. I've got to get these records, and it can just be, and it's really challenging, but it is something that can take a long time. So if you can get them beforehand, it's certainly going to help you progress the matter a lot more quickly.
Yes, and some people are just not very computer literate, so just getting those statements is
a big challenge.
Yes.
Yeah, absolutely. Yeah. So in terms of, I think we've spoken to some steps people could take early in separation to help them make sure it runs smoothly. One of those is getting your documents in place, and like you say, passwords, and what else did we say there?
Talk to a lawyer.
Talk to a lawyer, yeah, to get your steps in order. The other one I would say there is getting yourself supported. Like a lot of people and clients don't bother getting counselling or anything like that. And as I said, it is one of the top traumas in your life. You really should be getting yourself some additional support. And that's something that we would quite frequently say to clients, have you got some counselling support? What's your support system, and who can you lean on for some additional support here? Because it is a challenging process, and not all clients take on that recommendation, but I think it's probably one of the top things people need to do to allow them to make decisions and not get in a stage where they're, delaying getting documents because they're too overwhelmed.
Yes.
Yeah.
And I think it comes to the territory, being a family lawyer, we get clients who will, have concerns they want to raise with us, but ultimately I'm not a counsellor, I'm not a psychologist. I am really, I'm here to help you with your legal matter. And that's not because, I don't have time for you, although that can sometimes be the case. It's more about just getting the right support for the job. Someone who is able to help you navigate this situation, not from a legal perspective, but from an emotional perspective, because it's a lot to go through. It is a lot. And people shouldn't try and do it themselves if they can possibly avoid it.
Yeah, absolutely. And there's a lot of support out there these days with mental health plans and the like, and even some free counselling service, especially for children as well. And that's another area where I see that sometimes parents overlook, is to getting the children the right support throughout the process too, because as much as it's an impact upon you, it's a bigger impact on children who don't really have the capacity to fully appreciate what's going on or understand why it's happening. And that can, of course, lead to children acting out, right? They can act out with behaviors and symptoms because they're going under stress, and then parents can see it as being the fault of the other parent. But realistically, if they could just get the children the right support, sometimes that can alleviate some of the challenges that they may be experiencing.
Yeah, and that's quite a common one, and it's very hard to, as part of the court process, often we get family reports, which is like a report by a psychologist about the children. But a common thing I see is, one party will say, well, the children are acting up because of the other party, but then the other party, quite rightfully perhaps, says the exact same thing, because it's hard to say. It's probably a combination of both, and the change and the separation.
And conflict. If there's high conflict, that invariably impacts the children.
Yeah, exactly.
Yes.
Yeah.
I mean, that said, there are some cases where it is more one parent than the other. That needs to be acknowledged as well. That does exist and that does happen. But often it is a combination of both parents, and sometimes it's not having the awareness and understanding all the tools to support the children to navigate the process better, because they're not navigating it well themselves. And that's just an unfortunate reality that happens sometimes. And as you go through the court process and children are getting supported with psychologists throughout the process, sometimes those symptoms can be addressed, right? And parents having the awareness to change their own behavior as well can make a big difference, in my experience. So yes. So can you tell me a little bit about, I suppose we probably touched on some of these things, but in terms of couples who do it well, what would you say the couples who do it well do differently to those who are doing it poorly? What would you say that is different?
Well, I suppose the best case scenario for the majority of clients is when they come to you and they've already reached an agreement, and we're just, putting it into writing, crossing the T's, dotting the I's, and making sure it's ship-shape and filed with the court properly. That's probably the best case scenario, and that's where people do it well. So when they've had a discussion with the other party first before talking, well, perhaps not before talking to their lawyer, I would still say talk to your lawyer first, just so you've got an idea about what you might want to talk about, what your range of entitlements might look like, just to so you have an idea of the process and you can have a more informed conversation with your ex-partner. And then what I think people do right is they've actually sat down and had a conversation with the other person about what they want. Now, obviously, in some cases that can't happen. That's absolutely the case. But in the majority of cases, that can still happen. It might not be a fruitful conversation, but even if you sit down and try and have that conversation, you will provide information to us, because we'll know at least what they won't accept by way of an offer. It gives us a little bit of intel before the court or before you involve lawyers. And sometimes you will be able to reach an agreement, or you'll come very close to an agreement, so that by the time you're talking to lawyers, we're not going in completely blind, because the alternative is, I'm sure you're aware, is someone comes to us and, they haven't talked about it. We're not sure what they'd want. We're not sure what they'd take. And so we just start from ground zero. And it's just a bit harder to reach an agreement because you might be much further off. That's probably, best case scenario, I would say. Have a sit down, have a coffee, have a conversation with them, especially if kids are going to be involved, because if kids are going to be involved, it's a completely different dynamic, and you'll be talking to me or another lawyer for anywhere to 3 months to 3 years, but you'll be dealing with the other person for the rest of your life, most likely. So you need to be able to have those conversations if you possibly can. Don't just not trying to talk myself out of a job, but don't just go to your lawyer first at the drop of a hat. If you possibly can.
And that's great advice as well. And that's something that I also do tell my clients. Don't just rush off to lawyers and guard up, because that sets a tone for conflict as well. Like if you're coming in guns blazing and the first thing they hear about trying to resolve the problem is a letter from a lawyer saying, hey, that doesn't set up a good tone, because if the other person automatically thinks they're going to court and they don't want to cooperate. So that is not ideal. No one wants to get a letter from a lawyer. It's the first thing they hear about something.
Oh, yeah, exactly.
So, but 100% try and have some of those conversations where you can and get clear on, it's really helpful for a lawyer as well in doing your job if your clients do a lot of the homework first and actually have an understanding of what their assets are, like have a summary. This is what's in our banks. These are our vehicles. This is our superannuation. This is our house, and I think it's worth about this much. Have an idea, get some appraisals. So that you know what you got to work with, and you know what needs to be separated or what needs to be divided or separated between you. And I just go on, sorry.
I was just going to say, and that's what I often tell people, if I get a a free consultation call, I say, if you're not going to engage us at this stage, I'd recommend, putting down a schedule of the assets and liabilities and taking that to your coffee date to discuss, because, it's always annoying as well. Not annoying, I think annoying is the right word, actually, when, you've reached an agreement about this, and this, and then, there's that one vehicle we haven't discussed, and then all of a sudden that's holding up everything else. So, it's good to have everything and deal
it's
with
good
it
to have a list of everything, regardless whose name it's in. It doesn't matter whether it's joint or your name or their name. It all needs to be taken into consideration. Trust, businesses, all of it. And if it's complex, someone may want to go to their accountant and get them to help with that too. I mean, that's certainly something that some people need to do if it's quite complex.
Especially got businesses or something like that.
Or self-managed super funds and things like that. So I just want to touch on something you said there around making offers, because I'm conscious that some people won't really understand what that means in the context of negotiating.
Making what, sorry?
Offers,
yeah. So I mean, look, as a general rule of thumb, every case is different, but often how we approach property matters, for instance, is we would get disclosure, sort out what exactly is the asset pool, are there any missing assets, liabilities, so on. And then if we've got enough information from there, give some advice to our clients as to what sort of range of offers they might want to make. And then we'd make an offer to settle the matter by way of a letter, usually. So depends on the case. Sometimes we might set out, the facts and everything. Sometimes it'll be a bit more short and to the point. But it'll usually be what we call a without prejudice letter to the other party or to their lawyer saying, if you agree to keeping the house, paying me out this much, X, Y, Z, you keep this car, I keep this car, we'll sign a document and walk away. So it's basically a settlement offer. It's usually, and we'd exchange at least one of these before going to mediation. Can be more if the parties are quite close. They're quite far away, we usually see them just going straight to mediation after a round of offers.
Yeah. And so what are the options for dispute resolution then for individuals? I mean, sometimes there's avenues before becoming to a lawyer. So what options are available for individuals to try and resolve it if they're going to this round table conference between themselves and they're not getting anywhere? What options do they have?
Yeah, so if they aren't able to reach an agreement themselves, well, the next step, and depends on the type of proceedings, it actually is not going to depend soon with the new amendments coming in, but as a rule of thumb, and certainly shortly, you have to go to a mediation first. So there are some mediation centers, some low-cost ones that you can Google around and find. And it's sort of a choose your own adventure. So if you've got lawyers involved, we will help you. We will engage a mediator, propose a panel, pick one, set up a date, provide the mediator with relevant material, and then we will attend the mediation on your part. Or alternatively, you can do that yourself. So you can, again, there's a few low-cost mediation centers or family dispute resolution centers. And you contact them and they will send out an invitation to the other party to try and get them to come to a mediation when they're available. And if that falls through, you get a certificate saying you tried and failed, and so you're allowed to go to court. And as to what mediation is, it's usually, so you'll be in a room typically. A lot of the low-cost family dispute resolution centers might do it over the phone or by Teams. But typical one, if you're with a lawyer, your lawyer and you will sit in a room. The mediator will come into the room and say, what's the offer? They will then walk off to the other room, so you won't be with the other party 99 times out of 100. They'll be in a separate room, and the mediator will run from room to room and say, I've talked to them, this is the offer they're prepared to make. And so instead of sending a letter every few weeks with an offer, you go to mediation and you can exchange dozens of offers over the course of a day. So it's just sort of a good way to kind of reach an agreement as soon as possible. But because you've got the mediator going from room to room, it avoids a lot of that conflict, which we're, trying to avoid if we want a settlement.
Yeah. A couple other options I'm aware of there is where you can do like child inclusive mediations of parenting matters, which can be useful to some families, particularly if you've got some older children who wish to have a voice. And the collaborative process, which is more like an extended mediation, but you're actually you're in the same room with the couples are in the same room, so they're trying to solve it together. But obviously you need to be able to do that in that process, and some couples are
Yeah.
not able to do so. Therefore, mediation may be a better option for those couples who can't sit in a room together. And we certainly had some of those in our time, I can assure you. It can get pretty challenging in those dynamics, even going to mediation, to make sure people are not, staggering when people arrive and leave, and particularly where there may be some domestic violence concerns. And then, absolutely you want to be making sure that people are safe when they're going through any sort of negotiation process.
Yeah.
So you're just speaking into some changes that are coming in June, I believe they are. Is that, do you want to speak a little bit into that? Is that going to be requiring them to all attend?
Yeah, that's the long and the short of it. There's a few more fund amendments.
So it's always been the case in parenting matters, so it's coming in on the financial side of things too now. That and
there's also going to be there's a few amendments. They're going to a lot of just codifying what was already the case through statute. So the 4-step approach to determining property settlements. You are the ones they are including domestic violence as a relevant factor for assessing future needs, entitlements, which again was
already the case.
But I think they've sort of lowered the threshold there, is my take on it.
Made it more broad or expansive to cover more.
More expansive than the previous rule in Kennan, I think, which was a bit more severe. And also, but just because it's in the statute, it just makes it a bit easier to litigate on, and for people to understand what's going on as well. Like, what are the relevant factors?
Yes, I think previously it was, when you say codify, what you mean there is that it was already the law by case law or through the court system. The courts would apply it, but it wasn't actually written in the legislation where people could go and find it easily. Most people don't look at case law, and it can be tricky for individuals to go to understand how to apply case law unless you're a lawyer. So, yes, it just makes it a little bit easier for those individuals who may be self-represented to have or just in the early stages trying to figure out, what's the process here. I think there's something else about pets as well coming in, was previously pets were considered, but now
pets for property, and now they are companion animals.
Yes.
You cannot have shared custody of companion animals, but we are able to litigate over them. I am not too sure as to what extent we are able to do that. But there are now a list of relevant factors for companion animals that the court must consider when they're making an order. Again, it can only be an order for sole custody, if you will, of the companion animal. But I think
it's a big thing, though, and I think there's a gap there for some people in the system, of course, and particularly where animals are used as weapons as well in the legal system, which does happen. So I think it's it's a good progress forward, I suppose, but like all of these legislative changes that come in over the last, we had a big load June last year on parenting side of things, and now coming in the financial side of things. It's going to be a bit of time before we fully understand the impact of those changes coming through the case law and the application of that. So it's going to be a bit of time before we fully see, like you say, how we're going to be applying this in practice when it comes to animals and how broad is the domestic violence application of financial matters going to be, how broad is that going to be applied in practice, because we just don't know yet. So that's another interesting factor. But if you're in that situation, that's something that you ought to get legal advice about, because, like I said, they're new, challenging, or new waters in the space of family law to consider. So you'll want someone who's up to speed with the most current cases on that particular aspect, if there have been any as yet.
Yes.
Yeah. So, yes, in terms of formalizing agreements, how do you said, once you seal the deal, you want to sign it up. What are we signing up, Brent? I know, but I'm going to let you tell me.
So there are a few different options, and it depends on what you're doing. So with parenting, there's two main options. There's the consent orders, there's a parenting plan. So parenting plans are more informal. If you have a parenting plan, the court must consider it if they're subsequently looking at making parenting orders, but it's not binding, so it can't be enforced. So the majority of the time, especially if the kids are a little older, we would advise parenting orders, because they're enforceable by the court. And so those are just, ideally, again, they could be by consent. If you and your ex-partner have an agreement, we can file them with the court, and then the court will have a look at them, and if they think they're reasonable, they will put their seal on it, and then it's a court order. so it's enforceable. For financial matters, you've also got two options. So you can do what's called a binding financial agreement, where you're essentially signing an agreement with another party to contract out of the jurisdiction of the court. People also refer to these as prenups, you might have heard, but the
prenups if it's before you get married, right?
Yeah.
Yeah.
And with the binding financial agreements, you can do them before, during, or after de facto or marriage.
Yeah.
So binding financial agreements, they're good if both parties have lawyers, because both parties will need to see a lawyer. If you don't have lawyers involved, you can do consent orders or property orders, which would involve an application to the court, much the same as parenting orders. And again, even if you and your other party consent, ultimately it is the court which is making those orders. So if you've consented to something they think is very unreasonable, you'll get a please explain, and potentially they won't make the orders if they don't think it's fair. If you've got lawyers involved, they probably would tell you before you get to that stage, if the orders aren't going to be accepted, but just something to be aware of.
Yes, and if the orders won't be accepted by the court, well, then they could explore a binding financial agreement as an option as well.
Exactly.
To formalize something. And that can be particularly so if the agreements are a little bit outside the scope of what, I don't know, the status quo, so to speak. And it's very valid reasons for people wanting to do things differently, depending on their specific situations and the like. So that's definitely an option for some people who are wanting to do things a bit differently. So can you tell me a little bit about your practice and the approach you take? I mean, obviously, I think it's clear in your motto, assertive advocacy, compassionate counsel. So your approach sounds to be a little bit more collaborative, but you roll up your sleeves if you have to.
It's hard. I mean, it's a very lawyer answer, but it depends. And I think that, in particular in that early stage, pre-court, it's just a lot of negotiating, and that's the reality of it. I mean, if what you want is for someone else to accept an offer, you can't necessarily go fire and brimstone, and we wouldn't advise you to. So it depends, because there might be the situations in which it's called for, but as a general rule of thumb, we're typically a lot more collaborative and negotiation driven, I suppose, in the early stages. And then once you're in court, that's where I suppose we pivot to a bit more assertive advocacy. But as a general rule, it depends. Every case is unique.
Of course.
Everyone's life and relationship is unique.
And sometimes you do need to go guns blazing from the beginning. And in some situations where there is urgency or where there is risk that needs to be addressed. And in those cases, you should certainly get a lawyer if you're able to do so. Again, some people don't have the resources for that, but there's certainly free options out there with legal aid, and that's not so helpful, but there are some resources out there for individuals who are in that situation. So what is your number one tip, though, then, for those contemplating separation, looking to go down that path in terms of how, I suppose, some of those things it is?
Number one tip, talk to a lawyer. I'm gonna stay with it.
Of course.
I mean, it's not just us, though. Like, I want to make that very clear. There are a lot of lawyers who will offer free consultations for family law matters. I spend lots of time every day doing free consultations for family law matters, most of which don't go anywhere, but it's just a matter of, setting people at ease sometime, giving them the idea of where to go next. Because you go on the family court website and it is quite confusing.
It is not. It's meant to be.
A lot of good resources.
Absolutely, it is not so user friendly. But that said, there is a lot of information readily available online as well. If you know what to Google, some people don't even know what to Google, and that can be challenging. So having that information of, okay, you should consider this, or take a look at this, that can be really helpful. And that's something I support people with as well in my programs. Telling them where to go, telling them where to find the information or where to look, or sometimes, or telling them what they ought to be looking for right? Because people just
Yeah.
don't know what information they need to find.
Yeah.
And having that information is going to support you then to be able to move forward and maybe have those discussions, like you say, with the spouse about, okay, well, what are we going to do with parenting? What information do we need to make these decisions around parenting, particularly if you've got children with high needs that may have different structures. Maybe, 50-50 is not always the way to go in parenting. There are other options, even though commonly people in society believe that that's the way that things are these days, but that's not always the case.
No.
So having the right information to start with so you can make some informed decisions, like you say.
Yeah.
So I suppose then moving forward, we'll finish up, but I just wanted to check in. So give yourself a plug, Brent. Say again who you are, where people can find you, how they can contact you.
Yep. So my name's Brent Clements from Clements Fitzgerald Lawyers. Plug is, like I've said before, we do free 30-minute consults. They're just a phone call for the free consults, but we can do Zoom and meet in person. You can book online, give us a call. We're happy to talk about your matter.
And across Australia, except WA, anywhere across the country?
Across Australia, except WA. I think, as Cara mentioned earlier on, a lot of court matters now are remote. I have many clients who I have never met in person, which was very different to 3-4 years ago.
Pre-COVID,
absolutely.
Yeah, COVID changed the world in family law.
Yeah, so we're in Brisbane City, right next to the family courts, which is very convenient for us if we need to go to court. But for most people, they'd rather just pick up the phone or arrange a Zoom, and I understand that.
That's right. And something else I understand from your service as well that may be a bit different to other firms is that for some agreements, depending on the situation, you have some fixed fees. Is that right?
Yeah, that's right. So if you have an agreement, I think we said earlier, best case scenario, you've reached an agreement with your ex-partner. And if that's the case, great. Come to us with the agreement, send it through, even if it's just on a napkin, send me a photo of it, and we'll give you a quote for a fixed fee to sort out that. So parenting orders, property orders, both financial agreements, divorce applications, all these we do for a fixed fee if they're agreed.
Yeah. And also wills and estates you do as well. That's correct. Yes.
And also wills and estates, also fixed fee as well. So if you've got an agreement, we can do them for a fixed fee. I think that's
something else people need to consider in the separation space as well, is updating that if you have one. And if you don't have one, get one.
Exactly. No, that's a very good point. We should have talked about that. I should have talked about that. But update your will.
Yes.
Update 100%. Your will. And I might have to issue a slight redaction because I am not 100% sure if the June amendments do remove the requirement. Do impose a requirement for property matters to go to FDRC or mediation first. I'd have to double check. I'm not sure if they actually have. As a matter of course, if you've got lawyers, we always tell you to.
I think there's a dispute resolution process or the pre-court procedures, but I think you're right. I don't know that it's specific that they have to.
They do.
I don't think a certificate like you do in parenting matters. Section 60 CI, is that right? From my memory.
60 CC. Yeah,
it's not the same, but there's still a requirement to at least attempt to resolve things.
Oh, right. Yes.
Yeah. Okay. Well, thank you so much for your time, Brent. I really appreciate your knowledge and expertise. And whilst I know all this stuff, it's really helpful to have it translated from practicing law.
Well, it's good to give back. You taught me a lot of this, so
thank you. But yes, I'll upload this, and with all your details and contents, I'll pop it in the comments, so people will know where to find you and contact you. But thank you again. I really appreciate it.
Perfect. Good to speak to you. Thanks, guys.